Donald Trump gets gagged out of his prosecution taking place in New York. Now, there are two parallel levels to what's happening here, and the gag order came out from the lower level court, which is in the state system. Out of the Supreme Court of New York, Juan Merchan granted an order and a request to silence Trump, saying that he can't speak. And so we are going to go through that, but I want to make sure we understand what else is happening, because while this case is pending through the New York State Court, Donald Trump and his team have filed to remove this case from the state level court up into the federal level court. And we put together a full video on that called The Trump Invokes Federal Supremacy, which you can watch on YouTube or grab the link at spotlightlawyer.com/Trump. It is there in the Bragg section. So Trump wants to take this case out of the state court, bring it up to federal court, because he says it brings up federal issues like a federal election. And he also says there's other provisions of the law that will protect a federal candidate against state level harassment in the form of prosecutions when they implicate federal questions. So let's take a look at the actual gag order first, bearing in mind that this all may be subject to change. In other words, the federal court may take this case away from this judge and away from this state level court and carry it up into the federal system because it invokes federal questions and federal issues. Let's get into the actual gag order, because this by itself is a shocking development. We have Donald Trump running for president, former president. We have allegations that are many years old that have been bootstrapped on the back of wild, novel legal theories that have really not even been validated. And Trump is being prosecuted in the middle of his campaign for presidency again. And they're going to silence him. He can't even defend himself in the court of public opinion while all this is going on. The prosecutors can throw blows day after day, leaking to the media, but Donald Trump can't respond to this at all. Here's what the judge said. In the order, he writes, coming from the Supreme Court of the state of New York, this is a protective order. The people of New York versus Donald Trump, criminal charges in this case, saying that the court being satisfied with Alvin Bragg's office and the hearing conducted in May, they corrected this. They say that good cause exists for an order to restrict, defer, and make such other order as is appropriate with respect to disclosure of discoverable materials in this case. So the judge is saying, we got a request from Alvin Bragg's office. The lawyer representing this one is Catherine McCaw. She sent in a letter. There was an opposition motion. Trump's team responded, said, we don't need a gag order. We know those lawyers, Todd Blanche and Susan Nicholas. They conducted a hearing, and the order from the judge says, I listened to everything. Good cause exists. You're gagged. It is hereby ordered that any materials and information provided by the people to Trump's defense in accordance with their discovery obligations shall be used solely for the purpose of preparing a defense in this matter. So this big block of text is saying it's going to be coming in any way, right? Defense counsel, any form, any component, any materials, anything going to Trump, Trump org, Trump revocable trust, anybody. Any transfer of materials from the government to Trump is included in this. And it shall, not, may, or it's an order, shall be used solely for the purpose of preparing a defense. So you can't give it to journos. You can't post it on True Social. And do you notice here that this order is only applicable to Trump? Interesting. Order that any person who received covered materials from the government, if they receive them in any way, they shall not post anywhere to any third party website, including but not limiting to True Social. Look at that, the first one. So the order is specifically singling out Donald Trump. In other words, it's not saying to the government, you guys should stop leaking to the Wall Street Journal. I'm sorry, in this case, the Washington Post or the New York Times would be a better example. Trump can't share anything that he gets to Truth, to Facebook, to Instagram, to WhatsApp, any other things, YouTube, without prior approval from the court. Also ordered that any disclosure of names or identifying information of New York personnel other than law enforcement shall be delayed until the commencement of jury selection, and the people can redact names and other identifying information from the materials. So in the discovery, which we will never see because they've been ordered to not disclose it, right? The lawyers can't disclose anything. It's basically sealing this case. Ordered that those covered materials, and it's allowing redactions, and Trump can't communicate about it. Those covered materials are designated by the people, whether electronic or not, shall be kept in the sole possession and the exclusive control of defense counsel. Now, the lawyers can't copy, they can't disseminate anything. And can we be crystal clear about this? This is not a national security case. This is a bank record crime. This was one of the dumbest business transaction offenses that we've ever seen here. Trump got charged for getting an invoice from Michael Cohen. 1 felony. Invoice got logged in the bookkeeping software, 2nd felony. Trump pays the receipt, pays the invoice, 3rd felony, multiple times over the year, which sounds to me like a retainer. And they're charging him with crimes, and they're acting like this is all involving classified materials or something. This is about money with a lawyer called Michael Cohen. And all of this can't be disseminated, copied, anything. The defense attorneys are now limited. You got to come and you can't even copy your documents. You mean I can't even send an email with an attachment from your garbage prosecution to my assistant or something like that without going through your stupid rules? Shall not be disclosed. Defense counsel. It's hamstringing the defense attorneys. Defendant is permitted to review the limited dissemination materials only in the presence of defense counsel. So you can't send Trump a PDF of this and allow him to view it at his home. Trump shall not be allowed to copy, photograph. He can't transcribe. He can't do anything about it. Trump is also permitted to review the portions of the forensic images of the witness cell phones. So we have some cell phones containing material related to the events discussed in the indictment. So Trump can see very limited. He can see some of these things. Material evidencing any prior criminal conduct of the phone, communications or notes on the witness list, communications with law enforcement. He can see all of this stuff. That's nice. And information about Donald Trump. Anything related to the special counsel, Department of Justice, or those things, but it's all going to be protected. Further ordering that any portion of the images of the cell phones shall only be reviewed by defense counsel and those employed by defense counsel, except that after obtaining ex parte and in camera from the court, defense counsel may show Trump and other court-approved portions of the images to Trump. This is crazy. So Trump can't even see the evidence, except that after obtaining permission, defense counsel may then show Trump. So they've got a cell phone, probably Cohen's or somebody else. They've got forensic images of the cell phones. Only Trump's lawyers and Trump's legal team can review these documents. The judge doesn't even trust Trump with seeing them. He says, once you've seen them, you can reach out to the court ex parte. In other words, you can say, Your Honor, I'm just going to send you an email to your clerk and ask you for permission. And I'm going to show you in camera. I'm going to take the images that I'm intending to show Trump, and I'm going to bring them to you, Judge. And I'm going to say, I'm going to show him this. Only then the judge will say, okay, I'll allow you to show that piece of evidence to your client. Only then can defense counsel then show Trump other court-approved images. So Trump has got speed bumps. He can't even see the evidence without permission of the judge. It's the government's evidence against him. In theory, the defense should see all of the government's evidence against them because we have what's called the confrontation clause in this country, where we can see the evidence and build our defense against it. And they should give it to them in a thumb drive or however the defense wants it. But now the judge is saying, you've got to come back to me and get permission for every image. And I want to see what images you're asking for so I can keep tabs on what you're looking at and what you're showing Trump. Keeping tight reins on the evidence in this case. Further ordering that in the event that Trump seeks an expedited review of this order, any obligation that would exist on the part of the people to produce these are held in abeyance pending the determination of this appeal. If Donald Trump says, to hell with this, we're not following this order, we're going to appeal it, then you don't have to give him anything, actually. You don't have to disclose anything until it's determined what the appellate court says. Further order that portions highlighted in green in the people's motion in support are sealed. Signed May 8th, 2023 by Judge Merchan, Justice of the Supreme Court, the lowest level court in New York. Pretty amazing ruling. And it is limiting Donald Trump from not only speaking about the case, his lawyers from not being able to speak about the case. They have difficulty even accessing and showing Trump the evidence because the judge is putting speed bumps in front of them. And who knows what happens? One of the lawyers might go to the judge and say, Your Honor, I want to show Trump this. And the judge might tell the lawyer, you can't show him that. And I'm going to not even communicate about this because it was ex parte and nobody else knows about it. So it's not going on the docket. Your client is denied access to the evidence for, I don't know, some stupid purpose. National security. This is an old business records payments case. But this isn't about protecting anybody. This isn't about protecting or enacting justice in New York. It's about bringing maximum damage to Donald Trump and tying his hands behind his back as this case is proceeding. And New York is allowing it to happen. So while that is moving forward, there is a parallel proceeding taking place Remember, in a previous video, we talked about Trump filing a notice of removal, a full document saying the federal court is the more appropriate court to hear this case because it involves federal questions. And there has been a lot of activity in the federal docket. This is the federal case, which is really the same case, just in a parallel court, saying that we should take it out of state court and bring it upstairs. So a couple things happened, a lot of activity here over the last few days. May 4th, Donald Trump and his team filed the notice of removal, and we covered that whole thing. Several people are filing their notices of appearance. So Donald Trump, Susan Rose Nicholas coming in on board. Matthew Colangelo, representing the people of New York, submits his notice of appeal. We get notice of appearance, meaning he's now on the case. We had the case get assigned to Judge Ronnie Abrams, and then it was reassigned to another person called Judge Alvin Hellerstein. Then we got another notice of appearance from another Trump lawyer, and a couple motions were filed. One is a consent motion. This is an agreement between the state of New York and Trump's team saying we got to get a scheduling conference on the books so we can hash through some of these additional issues. And the judge did schedule a proceeding, and so let's go through the documents together. This is a jointly agreed upon motion. People of the state of New York, this is Alvin Bragg's filing, 3 pages, against Donald Trump. They say, pursuant to the rules, New York respectfully requests that this federal court schedule a conference at the earliest available date. Alvin Bragg's office has been in contact with Donald Trump's team, and they consent to the scheduling of a case conference. Currently, Donald Trump has been arraigned, was brought into custody in New York on an indictment charging 34 felony counts. That case is proceeding in New York. But on May 4th, Trump and his defense team filed a notice of removal to bring it out of state court into federal court. The statute that establishes the procedure for that removal provides the United States District Court, when that notice is filed, shall examine the notice promptly, and then they should make some decisions. Do an examination and then make a decision. So therefore, the people of the state of New York respectfully request the court schedule a conference soon. Trump's notice of removal does not operate to stay the state court action, meaning the state case is going to be proceeding. So that gag order that we just read is in effect until the federal court pulls it out from the state court. That proceeding is continuing on a schedule set by the trial court and the state law. An early case conference is set to schedule, and procedures for prompt resolution will therefore minimize disruption to our local prosecution, and let's get something scheduled. Respectfully submitted by Alvin Bragg, Matthew Colangelo. They said that they had agreement from Trump's team, and we believe that they did. They're making an avowal to the court. So Trump's team is on board with that, and the judge responded. And so we are going to get some action on this pretty quickly. Order regulating the proceedings came out from Judge Alvin K. Hellerstein, the U.S. District Court for Southern District of New York. He writes, I have studied the notice of removal and the attendant papers that just got submitted. In order that an evidentiary hearing may promptly be held, here's what the plan is. You got to submit any motions for remand and supporting papers. This is to Alvin Bragg. If you want this to go back down to the state court, get your filings in by May 30th. Opposition papers from Trump's team, you got to respond by June 15th and a reply by June 23rd. An evidentiary hearing is going to be expected over these disputed issues, and we'll be doing that on June 27th, 2:30 p.m. in New York. In the meantime, the proceedings may continue in the lower level Supreme Court of the state of New York. We're not interfering with that case yet, but we may, depending on what happens at the conclusion of this evidentiary hearing in June. Signed, Alvin K. Hellerstein, United States District Judge, issuing a ruling, and the case will proceed in the New York State Court. Of course, we will be continuing to cover this, and we'll see what Trump's team says in response in all of the various filings, whether they appeal the gag order and what the Court of Appeal says if they do. Thank you for subscribing wherever it is you're watching this, and we'll look forward to seeing you on the next one.